Listen to me very carefully, because what I am about to tell you is the single most expensive lie ever sold to the American middle class. I say that as somebody who has watched more than 1,000 families walk into a nursing home administrator's office, clutching a leather-bound binder, gold lettering still shiny, the words "Living Trust" embossed across the front like some kind of medieval shield. And I have watched every single one of them walk out 3 months later with absolutely nothing. No house, no inheritance, no legacy. The binder goes in the trash. The house goes to the state. Picture this, February 2024. A retired school teacher, we'll call her Margaret, 68 years old, walks into a strip mall law office outside Columbus, Ohio. Sign on the door, Estate Planning Specialists. She pays $2,500 cash. Money from her late husband's pension. Money she cannot afford to part with. The lawyer, 28 years old, licensed 14 months, hands her a revocable living trust. He tells her, and Margaret wrote this down on a yellow legal pad. Her daughter still has that pad on her kitchen counter. He tells her, now your house is protected. The state can't touch it. Probate is avoided. Your kids are taken care of. He smiles. He shakes her hand. He hands her the binder. Margaret cries a little in her car because she finally feels like she did the right thing for her family. She calls her oldest son that night. It's done. The house is safe. It was not safe. 11 months later, Margaret has a stroke. Massive. Left side gone, speech gone, independent living gone. The hospital social worker says the magic words. She's going to need long-term skilled nursing. In 2026, a skilled nursing facility in Central Ohio runs $10,400 per month. $124,800 per year just for the room and the bed. Add medications, physical therapy, the supplemental surcharges for two-person transfers. The family is staring at an annual burn rate of $168,000. Margaret has a total of $191,000 in liquid assets. You do the math. 14 months. 14 months of care and Margaret is medically indigent. The polite governmental term for broke and dying. A Medicaid planning consultant looks at the binder and laughs out loud. In front of the daughter, he says, "Ma'am, this isn't a shield. This is a receipt. This document tells the state exactly what to come take." Margaret is not stupid. She has a master's degree from Ohio State. She taught 4th grade for 31 years. She did everything the AARP magazine and the Sunday paper financial columnist and the strip mall lawyer told her to do. And she still got destroyed. Because the entire system is built on a single, beautiful, devastating piece of misdirection. The mills, and I call them mills because that is what they are, high-volume document factories cranking out 300 revocable living trusts a month at $2,500 a pop. They are not technically lying to you. A revocable living trust does avoid probate. That part is real. But avoiding probate and protecting assets from Medicaid Estate Recovery are two completely, utterly, cosmically different things. They are not even in the same legal universe. Avoiding probate is like locking your front door. Protecting from Medicaid Estate Recovery is like building a vault in the basement. The mill lawyer sold Margaret a front door lock and let her believe it was a vault. This is not official legal advice. It is a survival guide for an unguarded vault. If you still trust the strip mall lawyer who sold you the binder, ask him to explain on the record, in writing, the exact mechanism by which his revocable living trust will protect your home from a Medicaid Estate Recovery lien filed under 42 U.S.C. Section 1396P. Ask him to put it in writing. Watch how fast the smile disappears. Now let me explain what actually happened. Let me show you the legal mechanics, the part the binder did not explain. A revocable living trust is what the law calls a grantor trust. That word grantor is not decoration. It is a confession. It means you are still in complete and total control of every asset inside it. You can move money in, move money out, change beneficiaries on a Tuesday, and change them back on a Wednesday. You can dissolve the entire trust on a whim with a one-page revocation document. and the assets snap right back into your personal name like a rubber band. The IRS doesn't even give it a separate tax identification number while you're alive. It uses your Social Security number, because as far as the law is concerned, the trust is you. And here's the part the binder did not mention. If the trust is you, then any creditor who can come after you can also come after the trust. Period. Full stop. This is the central foundational principle of asset protection law in the United States, and it has been the law for over 100 years. If you can access it, your creditors can access it. The Medicaid program, when it pays for your nursing home care, becomes a creditor. A massive, statutorily empowered, federally mandated creditor with an army of recovery attorneys in 48 states. And when that creditor comes calling, the revocable trust is not a wall, not a moat, not a speed bump. It is a transparent shower curtain. The creditor pulls it aside and grabs whatever it wants. Now compare this to what an irrevocable trust actually does. An irrevocable trust, specifically the variety known as a Medicaid Asset Protection Trust, or MAPT, operates under a completely different legal philosophy. When you fund a properly drafted MAPT, you are performing what elder law attorneys call an alienation of assets. You are making the assets no longer yours. You give up dominion. You cannot revoke. You cannot amend. You appoint somebody else, usually an adult child, as trustee. That trustee owns and controls the assets, subject to the legal terms you locked in on the day you signed. You retain the right to live in the house for life, and possibly to receive income from trust investments, but you do not retain the right to grab the principal. Once the principal is in, the principal is gone. And because it is gone, because you have legally and irrevocably alienated those assets from yourself, those assets are no longer reachable by your creditors, including Medicaid. That is the entire game in 2 paragraphs. Revocable trust. You keep control, Medicaid takes everything. Irrevocable MAPT. You give up control, Medicaid takes nothing. The mill lawyers in 2026 are selling revocable living trusts at approximately 400,000 documents per year nationwide, charging an average of $2,400 per package, roughly $960 million per year in revenue. And the overwhelming majority of those documents will fail catastrophically the moment the senior needs long-term care. $960 million to sell paper shields. The actual document that works, the Medicaid Asset Protection Trust, costs between $5,000 and $12,000, requires a real elder law attorney with specialty credentials, and is exponentially harder to draft. So guess which one gets pushed in the Sunday paper? Guess which one shows up in the strip mall office? Here is how the Medicaid qualification process actually works in 2026. When a senior applies for Medicaid long-term care benefits, the state agency conducts a resource assessment. They demand 5 full years of bank statements, 60 months, every transaction, every withdrawal, every transfer, every birthday gift to a grandchild. They demand titles to every vehicle, deeds to every piece of real property, statements for every brokerage account, every IRA, every 401k, every annuity, every life insurance policy with cash value. And they demand the full text of every trust document the senior has ever created. Here is where the revocable trust dies in broad daylight. The caseworker opens the binder, flips to page 3, finds the standard revocation clause. The clause that reads, "The grantor reserves the right to amend, modify, or revoke this trust in whole or in part at any time during the grantor's lifetime." She circles it with a red pen. She stamps the entire trust as a countable asset. Under federal Medicaid regulations at 20 CFR Section 416.1201, any asset over which the applicant retains legal authority to liquidate is by definition an available resource. The trust assets get added to the senior's personal assets, and in most states, you are allowed to keep $2,000. Not $200,000, not $20,000, $2,000 in countable assets. Everything above that has to be spent down before Medicaid pays 1 penny. 3 states, 3 brutal realities. In Florida, the homestead exemption is robust on paper. Primary residence excluded from countable assets up to $713,000 in 2026. But the day after the Medicaid recipient dies, the Florida Agency for Healthcare Administration files a notice of claim against the estate. The homestead protection expires the second the applicant stops breathing. In Ohio, where Margaret lived, the situation is more aggressive. Ohio is an expanded estate recovery state, meaning recovery is not limited to probate assets. Ohio Revised Code 5162.21 gives the state explicit authority to pierce a revocable trust. The Ohio Department of Medicaid does not even need to go to court. They file a lien. They demand payment. The trustee, usually one of the kids, has 30 days to either pay the lien or sell the house. In California, after 2017 reforms, the recovery program was scaled back and limited to probate assets only, making California a relative oasis. But California seniors who move to Arizona or Nevada lose that protection the moment they establish residency. Both states have aggressive, expanded recovery programs that pierce revocable trusts. 3 states. 3 completely different outcomes. 100% of the seniors in those states were told the same thing by their mill lawyer. Your house is in a trust. You're fine. Now meet the villain properly. The Medicaid Estate Recovery Program, MERP, came into existence in 1993 under the Omnibus Budget Reconciliation Act. OBRA 1993 made estate recovery mandatory for every state. Every state Medicaid agency is federally required to seek recovery from the estates of deceased recipients aged 55 and older for any long-term care services Medicaid paid during the recipient's life. States can recover from the probate estate at minimum. Expanded recovery states, 26 out of 50 as of April 2026, recover from non-probate assets too, including revocable trusts, jointly held property, and pay-on-death accounts. The mill lawyers know this. They have been told this in continuing legal education seminars every year since 1995. They continue selling the revocable trust as asset protection anyway, because $2,500 times 300 clients per year is $750,000 in annual revenue. And the failure of the document only becomes apparent after the senior is in a coma and unable to file a malpractice complaint. It is the perfect crime, running uninterrupted for 33 years. MERP does not collect during life. MERP is patient. MERP files its claim exactly 30 days after the death certificate is recorded. The claim is filed against the estate, which in the case of a revocable trust holder includes the revocable trust, because the trust collapses into the deceased grantor's estate the moment the grantor dies, by operation of the very document the grantor signed. For Margaret's family in Ohio, the lien arrived 6 weeks after she passed. The amount, including all skilled nursing charges, all medication costs, all supplemental fees, $387,426.16. The home was worth $420,000. After realtor fees, closing costs, and the lien payment, Margaret's 3 children received a combined check for $17,200, $5,733 each, for the home where they grew up, for the home that was supposed to be in a trust, for the home the binder said was protected. What does the document that actually works look like? The Medicaid Asset Protection Trust is irrevocable. It must be irrevocable. The instant a lawyer tells you he can draft you a revocable version that still protects your assets, walk out. He is either lying or incompetent, and either one is fatal. The MAPT is funded with the assets you want to protect, typically the primary residence, sometimes a second property, sometimes investment accounts. The trust is drafted with an income-only provision. You retain the right to receive income generated by trust assets during your lifetime, but you do not retain the right to access the principal. You can keep collecting rent from a rental property held in the trust. You cannot sell the property and pocket the proceeds. The principal is gone. alienated, no longer yours. And because it is no longer yours, it is no longer countable by Medicaid. The document also typically retains a limited power of appointment, allowing the senior to change which beneficiaries inherit the trust assets at death. This preserves step-up basis treatment under IRC Section 1014. When the grantor dies, the trust assets receive a stepped-up basis to fair market value as of the death date, meaning the kids inherit the home with a brand new tax basis and can sell it with zero capital gains tax. If your home was purchased in 1978 for $60,000 and is worth $450,000 today, without step-up basis, the kids pay long-term capital gains tax on $390,000 of appreciation, roughly $97,000 in combined federal and state tax. With step-up basis, that bill drops to zero. Properly drafted MAPTs preserve step-up basis. Improperly drafted ones do not. This is why the $5,000 to $12,000 price tag for a real elder law attorney is the deal of the century. The avoided capital gains tax alone often exceeds the legal fee by a factor of 10. Now, the look-back period. The Medicaid 5-year look-back, codified at 42 U.S.C. Section 1396p(c), means any transfer of assets made within 60 months of a Medicaid application is subject to scrutiny. Transfer assets into an irrevocable trust on January 1, 2026. Apply for Medicaid on January 1, 2031. You are clean. The transfer is invisible, but apply on December 31, 2030, and you are inside the look-back window by 2 days. The entire transfer counts as a disqualifying gift, generating a transfer penalty calculated by dividing the value of transferred assets by the state's average monthly nursing home rate. In Ohio in 2026, the divisor is approximately $7,400. Transfer $400,000 worth of home equity 2 days too late, and you have generated a 54-month period of Medicaid ineligibility. The right answer to "When should I set up a MAPT?" is 5 years and 1 day before you need it. Since none of us know exactly when we will need long-term care, the right answer is as soon as possible. Ideally in your early to mid-60s while you are still healthy. The window of opportunity is closing. 3 converging trends are crushing seniors simultaneously. First, nursing home costs are inflating at roughly 7.5% per year. Today's $10,400 per month becomes $14,940 by 2030. Second, state Medicaid agencies are getting more aggressive, with at least 4 additional states expected to adopt expanded recovery laws in 2026 to 2027 legislative sessions. Third, the federal Medicaid look-back is being studied for extension to 84 months. Proposals already circulating in congressional subcommittees. Find a real elder law attorney, not a mill, not a strip mall generalist. Somebody with the CELA designation, Certified Elder Law Attorney, accredited through the National Elder Law Foundation. Ask them on the phone, before you make the appointment, what percentage of their practice is dedicated to Medicaid planning. If the answer is less than 50%, hang up. Ask how many MAPTs they have drafted in the past 3 years. If fewer than 30, hang up. Ask how their planning has performed in front of state Medicaid agencies. Margaret's family lost $370,000 of inheritance because Margaret saved $7,500 on the wrong document. The math is not subtle. The math is screaming. Don't be Margaret. Get the right document. Get it now. Save this video to your private library right now. Because the moment a hospital social worker says the words, "She's going to need long-term care," your brain stops working. Adrenaline floods your bloodstream. You forget every financial concept you have ever read. You start signing whatever the nursing home admissions packet puts in front of you, because the alternative is wheeling your mother out into the parking lot in February. This video, saved to your favorites, becomes your defense manual in that moment of panic. You pull it up on your phone in the hospital parking lot at 2 in the morning. You watch it again. You remember. You stop. You call an actual elder law attorney before you sign a single nursing home admissions document, because some of those nursing home contracts contain responsible party clauses that try to make the adult child personally liable for the parent's bill. Here is what a properly executed asset protection plan looks like, step by step. Step 1. Comprehensive asset inventory. The attorney goes line by line through every account, every property, every vehicle, every collectible, every life insurance policy, every annuity. Nothing gets skipped. Step 2. Family structure analysis. Who are your children? Are any disabled? Any facing bankruptcy or divorce? The beneficiary structure has to account for every one of those scenarios. Step 3. Housing strategy. Is the primary residence going into the MAPT? In states like Florida, Michigan, and Texas, the Ladybird deed, an enhanced life estate deed, allows the senior to transfer the remainder interest of the home to children while retaining full lifetime control, including the right to sell, mortgage, or revoke. The Ladybird deed is not a trust, but in those specific states, it accomplishes some asset protection goals at a fraction of the cost. In states that do not recognize it, the MAPT is the standard tool. Step 4. Liquid asset strategy. Some assets stay outside the trust to fund living expenses. Some get transferred in. The ratio depends on life expectancy, current health, and projected care timeline. Step 5. Drafting, which involves 3 to 5 distinct legal documents: the trust instrument itself, a pour-over will, a financial power of attorney, a healthcare proxy, and a HIPAA release. Step 6. Funding the trust. Recording new deeds at the county recorder's office, retitling brokerage accounts, updating beneficiary designations. This is where most DIY trusts die. Seniors create the trust document and never actually transfer anything into it, leaving the trust empty and useless. An empty trust is a piece of paper. It is not a vault. 3 state look-back nuances you need to know. In California, the look-back migrated to the standard 60-month window in 2024 following federal benchmarking reforms. But a transitional rule still applies for transfers made before the effective date. In New York, the 60-month look-back applies for institutional care. New York implemented a 30-month community look-back in phases beginning in 2025, with full enforcement active in 2026, closing what elder law attorneys called the New York loophole, which had previously allowed asset transfers the day before applying for home health benefits. In Florida, the standard 60-month look-back applies, but Florida is one of the few states that does not currently have a community look-back, meaning home health benefits remain accessible without the full 5-year planning horizon. A senior in Tampa has a planning landscape that looks completely different from a senior in Manhattan, and a senior in Sacramento has a completely different toolkit. The mill lawyer selling the same revocable trust template in all 3 states is committing professional malpractice in slow motion, across multiple jurisdictions simultaneously. Drop your story in the comments. Do you currently have a will, a revocable living trust, or an irrevocable trust? Did the person who sold it to you explicitly warn you about Medicaid Estate Recovery? Did they use the words estate recovery out loud during your meeting? Did they explain the 5-year look-back? Did they put a disclosure paragraph in your engagement letter? Or did they smile, hand you the binder, and let you walk out thinking your house was bulletproof? Send this video today to one friend who proudly tells everyone their house is in a trust and therefore protected. That friend is one stroke, one fall, one heart attack away from a Medicaid application that will vaporize the inheritance their kids are counting on. One conversation now saves their family $75,000 later. Send it today.